technology. It will be the death of me before we're all finished with this. We're going to go without slides today, and you'll just have to imagine the pictures that I'm talking from the slides. Thank you so much for coming. I see some people who were here last time, and now I see some faces that were not here last time. So thank you so much for coming. We've got handouts for the second session, and we also have the ones from the first session. So any of you that didn't get the handouts or the homework for the first session, just let me know and Hank will get those to you. I'm going to do a recap of the last time because we didn't have any kind of recording, and I'm so sorry we don't have the slides, but we will do just the recording of the information. And what I wanted to do was a little bit of a recap of our first session, which was globally about planning. And the planning, what was shared was that everyone here at Westminster is like head and shoulders above the rest of the crowd in general because you've already planned. You wouldn't be here if you weren't a planner. So you have done the hardest work. I congratulate you for it, and it makes you just a willing and able audience, which excites me. What we discussed in detail, and I'm going to cover it briefly, is that every one of us sits at one of three stages in our life available to make a plan. Stage one is what we're in. We have the cognitive and physical ability to put together a plan, gather up all our documents, put those in writing, and hand it off to our loved ones so that they'll have a valid plan to follow. That's the ideal planning. Stage two is a lot of people that I meet in my clinical practice. They come to me, either the individual or their family members come, and there is no plan. They may not have legal documents. The children may not know what the parents want. And so that can be a very valid plan as long as you still know exactly what you want, what you don't want, and who would be named to carry out your plan. Then with assistance, you can have a stage two plan that is very valid, very effective, and you can age your way. The worst stage is stage three, and that has to do with those who didn't plan at all. And without planning, what happens is someone else steps in and does the best they can to take control and execute a plan from guesswork. That's what we all absolutely want to avoid, and I think you'll agree with that. So let's plan in stage one. Stage two is the worst case scenario, and totally avoid stage three. The next thing is to understand that planning is not just doing legal documents. It's not just deciding what you want medical or just going to your financial planner. There are actually four distinct parts to planning. It is legal, medical, financial, and personal. Now the legal, everyone had homework for to do that came last time, so we're going to delve more deeply into the legal today. The medical, we're going to dig into the very last session because it's what I love the best as a nurse. The financial is one of those sections that I don't know well enough to give you any kind of decent advice other than the fact that your family members, the people that are going to step in for you, absolutely need to know what your bank accounts are for. Which ones that if they close the bank account, they will risk stopping your Medicare, your pension, your Social Security, everything that matters to keep your life going. So make sure at the very, very least that they know what account is something that is off limits and can never be closed unless they reroute all of your deposits in your automatic bill pay. So that's the most important part of the financial, that you don't forget that. And then personal is everything else that doesn't fit into legal, financial, or medical. And that's things like planning your funeral, things like what falls outside of your will that you want to designate. I have seen family after family torn apart and children who no longer speak to each other after the parent's gone because of who got great-grandmother's blue vase. So you can list special bequests, you can label them, you can give it to them before you die, you can do anything you want. But give the gift of making that decision where it's your responsibility, not the responsibility of your kids haggling that out. And everything that I'm going to talk about comes from real life experience. I'm a nurse who spent 20 years at St. David's, loved that hospital system, so I'm a little biased towards it. But 20 years in the hospital, from critical care to cardiac care to med-surg, and then spent the last, more than that, 25 years in the community. 23 of those are with my own company that I started just as a private practice back in 2000 when people were having trouble navigating medical care. I look back at that and that was a dream by comparison to today. What I thought was difficult and what my patients thought was difficult 23 years ago, I wish it were back there, where doctors, hospitals, facilities all had the time to give you what you needed. But that's become, even when people want to do their best, it's very fragmented. So the lessons that I learned from my patients, I actually sat down because, as we all know, we're not going to remember our most important stories in life the rest of our lives. So I sat down and wrote this little book, a storybook. It was a storybook of how you can age your way. And it was patients of mine, family members, what they went through, those who had a really smooth course, those that had bumps but wound up getting what they wanted, and the disasters. It was the good, the bad, and the ugly. So I wrote this little storybook. It's back on the back. There's a 2-book series that I wrote back in 2016. And the first was a storybook to motivate people to plan. But then it made no sense to motivate people to plan and then not give them a structure where they could write down everything that my families had been so generous to teach me. All of the legal forms, the medical, the financial, what needs to be shared, the accounts, what you use this account for, what your medical wishes are. Write it all down. Document it. Gather everything together and share it with your family members. So the next book was actually a blueprint, and it's on the back too for y'all to look at. These are available on Amazon, but they're not the only ones. There are other planning guides, workbooks, blueprints where you can write things down. And even someone who does 15% of it, 20% of it, it's more than what they're doing now, because many of them are lessons learned after the fact that family members would come back to me and say, I'm so sorry that I didn't do this. And it's my fault, because I never thought of it. There are things that you don't think about until you experience. So you're getting the benefit of all of that experience. And then once everything is put together, and it takes a long time, it took Hank and me over a year to get our plan put together. And I'm very organized. Hank's a mess, but I'm very organized, and I thought this thing would be buttoned up in 60 days, and it took a year.
Could have been done in a month if it wasn't for me.
No, not at all. But it really did take some time. But the best thing was that when we were finished, we gathered all the kids together and we went over our plan with them. That's the critical piece. You can do all the planning and documenting you want, but unless it is in an organized format handed over to your responsible party, it's worthless. So that's the nice step, and we've made it into a yearly party that we gather every year, and they spend 1 hour a year looking at their old parents that are getting older every year, but they're a part of the plan, and it doesn't hurt them to look at that instead of just playing and having a good time. So you can start a family tradition with that. The thing that we talked about and your homework assignment had to do with legal documents. And everyone got a list of legal documents to look at, to figure out where are your documents, where are the originals, what do you have, do you even know where anything is? Did anyone have trouble with this form as far as locating their original legal documents? No one had any trouble finding out where their original, come on now. Okay, let me rephrase it. Who did their homework? Were you able to put your hands on your original legal documents? Okay. Did you have a?
It took a moment.
It took a moment.
Yeah, my brother would have been hosed.
Yeah, yeah, because you don't really think about that. You do it, and when it's done, you're done and you move on. Did anybody have trouble with the people who were listed? Did anyone have someone listed on your legal documents that is no longer the choice you would make? Okay? So who was listed? Was it someone who you were no longer connected with, or somebody?
There were several. One was successor trustees. I realized one of them was not in a good place in their life to do it. Another was a bequeather, benefactor, whatever. And I realized dumping a lot of money on them would probably wreck their life. And so that needed to be adjusted somehow.
So their lives had changed, where they were no longer appropriate. And so everybody else here, every person you have named is still alive, able to step in, and do they know they're named? Personally, have you talked to every alternate so that every person who's listed knows their name? You're remarkable.
That's why we're here. That's how we got here.
Okay, Kathy says that's how we got here, is being remarkable people. Well, congratulations, I continue to be impressed. Yes, do you have a question?
No, I was going to make a comment. Not only the name the person, but then is there a process in your documents for naming a successor? Because I had a situation with my uncle where the only person named was his wife, and she was no longer cognizant to be able to do it, and there was no procedure for being able to name a successor. So we had to go and redo all the documents. I went with my cousin, his daughter.
Yeah, Tony's talking about a relative who named the spouse, which I guess most of us do. But then what about the successors? And that's something that we covered last time, that everyone needs really 2 alternates of a younger generation. Because a spouse, you know, you're somewhere around the same age, very often cannot act in that capacity anymore. They're deceased, they're cognitively declining where they can't make those real executive function decisions. So that's one of the things on your documents. Do each of you have at least 2 alternates, and alternates of a younger generation? You don't have to tell me. You can keep your secrets if you don't want to. But those are good documents. They're valid documents that you don't have to go back and redo. And I had someone from the first presentation who emailed me that when she looked at her documents, she had to go back and redo them from scratch. So don't be ashamed or afraid to redo them from scratch. Yeah.
The other thing is, look at the documents. I had a situation with my mother-in-law where she had the power of attorney. She was very proud of it. She gave a copy to her daughter, my wife, and I looked at it before I put it in the safe, and I realized, gee, the lawyer had never had her sign it.
Oh, she never signed
She
it.
never signed it, so we had to go back to the attorney and have him redo it and sign everything, because, you know, it's gonna be signed and notarized and all that.
Yeah, that'd
So
be
you
a
gotta
good
look at the
idea.
documents, 'cause lawyers make mistakes.
Yeah, yeah. And I'll tell you what is funny, we work with a lot of law firms because of the type of work that we do at CareFor. And one of the lawyer groups says all their documents, when they execute them, their clients pay in advance for the documents. And there's a significant percentage of people who'll do all the work and they will never come in and sign them. And they just sit and they call them and they call them again. And they have beautiful documents sitting at the law office unsigned. So they're invalid. But I promised you prizes. Anyone who actually did the exercise? Let me see how many of you. Okay, that's good. Well, I promised prizes, not grand prizes. Here's your prize. It is one of those gel ice packs. And it may not be grand, but I promise at some point you're gonna use this thing, because we use it all the time. But since we're now in 2023, you know, everyone gets the participation trophy. Every one of you gets a prize for just coming today. I'm so grateful that you're here. What I'm going to talk about in some detail has to do with guardianship. And I don't want to beat it to death, but I want you to understand it from several perspectives. It's really, really important. Guardianship is the biggest motivator to get your legal documents done, and as Tony brought up, to have alternates that are already listed in your documents. Because guardianship is a lawsuit. My company's a guardianship program, so I may be a little skewed because it's one of the major things that we do, but there's a lot of guardianship going on, either when documents aren't done or there is conflict with the family. You can have documents that are done, but any family member, any person can go in and file suit for a guardianship. So what's so important is to actually have your documents done and make sure that the reasons for guardianship don't happen to you. A guardianship's needed when you can no longer safely, intelligently communicate safe or sound decisions. It's a road most of us will be on at some point. I just lost one of my patients last week at 107 years old. She fired me when she was 105 because I took her blood pressure, which made her feel old. She needed a different nurse working with her that would not make her feel old. So I handed her off, and for the last 2 years, she worked with another nurse. She was very unusual, had been having some chest pain, went in the hospital, had a blockage, had had a heart attack. And there was a huge ethics debate about whether she would get a stent or not. She was 107 years old, sharp as a tack. She decided she wanted it. They put in the stent, all went well, but her recovery, she kept going into congestive heart failure. And they kept draining fluid from her. Her lungs were filling. And after they'd done that twice and they were going back for the 3rd time, she said, "No, thank you. It's been a good run. I'm done. And she made the decision. And she was gone quickly. The majority of us will not travel that path, where we are that alert, that with it, and can make the decisions ourselves. I applaud her. If I had her permission, I'd show you her picture. She's remarkable. But in the face of guardianship as a possibility, people can have a guardianship if they're at risk of abuse, neglect, or exploitation. And guess who is at risk of exploitation? Every one of us. Just because of our age. Answer your phone calls sometime, or your emails. The experts that make a full-time living making money from us and getting us to release our bank accounts and our social security number. We're the poster children. So it happens. And when someone is exploited, then a guardianship lawsuit can ensue. If they have no responsible party, or if you've executed your documents and someone says, you know, Mom was really confused when she did these documents, I don't think they're legal. I think someone forced her into it and they're not valid documents. So you can encourage everyone to do this before, or if there is a family conflict. We see a lot of that, where the kids don't get along, and so they're gonna fight the documents. You really shouldn't have Johnny as the power of attorney for the finances because he's never worked a day in his life, and they can file a guardianship lawsuit and take you to court saying that you need to have a guardian in place. When that happens, a doctor steps in and he does a physician's certificate of medical examination saying whether you have capacity or not. And you could be totally incapacitated. You could be just partially, where maybe you can't manage your finances and file your taxes. So you need a financial power of attorney, a financial guardian. Or maybe you can't make medical decisions. So it could be total incapacity or partial incapacity. But once there's been a determination and one of your evil children has gone and filed for guardianship to negate your legal documents, then it can go to the next step. The court assigns a cause number to it. They give the guardianship documents to a constable who wears a gun, goes to the house of the proposed incapacitated person and serves them with their guardianship lawsuit paperwork. Of course, you have to be informed if there's a lawsuit naming you, like when you get a divorce or when something like that happens. You have to be informed. And so that's delivered to the individual. An attorney is assigned from the court to represent that individual and see if they want the guardianship or not. Well, what do you think? You think most people say, sure, let me have guardianship. Let me be under the court influence. No. They always say they don't want the guardianship. And then it's the lawyer's job to go and represent their wishes to the court. The judge hears all the testimony, determines if a guardianship should be put in place or not, and what the limits of those guardianships are. Are they total? Or can the person still be allowed to drive, still be allowed to marry, determine where they live, manage day-to-day finances? There's a list of what they can or what they can't do.
Where do you get this list? And what constitutes a rock-solid guardianship?
A rock-solid guardianship is when the person is incapacitated and the physician has determined that they're incapacitated either partially or totally. that either they don't have solid legal documents where someone is willing, ready, and capable of serving as their power of attorney, or that their documents might have been done when their capacity was incapacitated, and that someone has filed to take over legal responsibility for that individual. Does that make sense?
Yes, but I want to know, what is a rock solid guardianship? Is there a list of qualifications?
For the guardian.
Yes.
Okay, she's asking about who can serve as a guardian. The person that can serve as a guardian can be a family member, it can be a friend, it can be your next door neighbor, it can be one of your children. And if there's a huge conflict, as very often happens, then the judge may put in a professional guardianship organization. There are two in Austin. One is my company, Care4, the other is Family Elder Care. So if there's a huge family conflict, by putting in a private professional guardian, they are tasked with taking the legal responsibility and then communicating with each of the children or the family members, so they all get the information, that there's not one withholding from all of the children. But once that's in place, a guardianship is forever. The court has legal oversight for the rest of that individual's life, except in very, very rare circumstances. I'm going to share my very first guardianship case with you and ask you to pull out what's on the slide, this paper that says substituted judgment. My first guardianship case came out of nowhere. The company was less than a year old, and the probate court called and asked me if I would serve as legal guardian for a young woman in her early 30s who had been hit by an 18-wheeler and sustained a traumatic brain injury. With this, she was in a coma, paralyzed, on a breathing machine, a feeding tube, couldn't speak, couldn't eat, couldn't move, couldn't do anything. And so her family came in. Of course, she had no legal documents already, so the family came in and her sister became her guardian. And that was heartbreaking. They were a very close, large family. It was heartbreaking. However, in retrospect, it looked easy by comparison to what happened when she started waking up. She was mad. She was mad at everyone, and here her sister had legal authority over her. She couldn't speak well, she was partially blind, paralyzed on one side, just learning to eat and drink, and her sister was making all of her decisions. Well, she was so mad at her. And the person's name was Dory. She's given me permission to share her picture and her story. And I wish I could, but maybe next time when technology works, I will. But Dory was so angry that she made all kinds of accusations against her sister's husband. Terrible lies, because she wanted to hurt everyone. Hurt them just a little bit as much as she was hurting. Well, those lies landed on the front page of the city section of the Austin American-Statesman, and her sister said, "I'm out." The family still wanted to be involved. They did not want any legal responsibility, so the court called me and said, "We know you can do this. We know you're a nurse. You can take care of it." And I said, "Yeah, I can take care of Dory and her clinical needs. You mind telling me what a guardian is before I step into this?" Well, that was back in late 2000, early 2001, which was the wild, wild west of guardianship. All I had to do was get in touch with the National Guardianship Association, take their little test, take an oath, pay them my money, and I was a guardian. It's not like that anymore. There's a whole lot more scrutiny now. But back then it was pretty easy, and I read through everything and agreed with every single thing. You know, as a nurse, there's an ethical role that we walk in. And 90% of everything they said was familiar and comfortable, and I could work that way, except for this substituted judgment thing. It really, really stuck in my craw. Because what it says, that when you are making a decision for another person, and this is the lesson you need to teach and train your responsible parties. When you're making a decision for another person, you do not look first at what is in their best interest. You first look through their eyes, walking in their shoes, and substituting your decisions for the decision that they would make if they had capacity. And I thought that was strange. I've always been a nurse. You know, someone's bleeding, you stop the bleeding, someone breaks an arm, you put it in a splint. You know, they're just things you do for people's best interest. That is not what you want your responsible party making decisions for you about. Because what they think is in your best interest may not be what you want. My 107-year-old would have been in her best interest to drain her lungs a third time, and a fourth time, and a fifth time, and a sixth time. Would have kept her alive. That's not what we're asking anyone to do for us. We are asking them to know us, understand us, and treat us by the highest ethical standard of making decisions for another person, and that is using substituted judgment. So part of your homework is to help explain this to your children. I'm going to take you through the painful path I had to go through with Dory. By the time I took her over, she was still in a wheelchair but was able to walk some. I was beginning to be able to understand her language. She was still in a facility, but you know, 18-wheelers, they kind of pay off when they run into you, and so she had a settlement. She wanted her own home. She'd never had her own home before, but now she could afford it. She got her own home. You know, when you're parenting and where you're looking at best interest, it would have been in her best interest to stay in a facility for the long term. She didn't want it. I had to look through her eyes, walk in her shoes. She got her house. She had 24-hour care. She wanted less care, more freedom. By then, she could walk. She could pick up the phone and call. I could not be assured that harm would come to her. I could be assured what she wanted. We cut down the staff. We cut them down further. She finally was on her own, in her own home. This head-injured young woman who was quite impaired still. Following that, she wanted to go to the mall by herself. Okay, we went to the mall. I aged 20 years in the 2 hours she was there. Because you didn't have cell phones then. She got dropped off by a cab with a pocketbook with money. And she came back and she called and reported in, and she was fine. Substituted judgment. She wanted to date this young woman, impaired, with a pretty substantial trust. She was going to go date. She did. She fell in love with Albert. I can't believe he married her. or even thought about marrying her. After I did a background check, fingerprints on him, went and showed up at his work unannounced to see, did he really come to work on time? Was he a good engineer? Did he know what he was doing? He checked out. The interesting part was when finally everything was put to rest and they got permission from the guardian that they could marry. When we marched down to Williamson County Courthouse, no one knew what to do. Signing up on a marriage license, that's legal. Dory did not have the right to sign any legal document. They pulled in every judge, they pulled in every, what those reporter things are, you know. They pulled in every person they could and no one could decide. So in the final analysis, the three of us signed the marriage license. So I do have another husband and another wife. That was 15 years ago. They're still married. Dory will never drive. She will never look or act like us. She will always live the life she wanted to live because of the standard of substituted judgment. We went back to court eventually and she regained all of her rights. She was no longer totally incapacitated. She no longer was on her own. She has a husband who loves her. There have been many, many more guardianship cases. If you can train, I know it's our kids' knee-jerk reaction is to parent us. We do not need our responsible parties parenting us. They're not here just for our safety. They are here to apply our wishes. And the only way they can apply them is to know what they are. So the big question is, will your responsible party, when you think about who's named first, if you provide them with all of the information of what you want and don't want, will they carry your wishes forward, even if it's not their ethical stance? Do you feel like you have the right person to speak for you? That's the big question. I worked with another patient, Claire, and she must have told me 100 times, if I had known I was going to live this long, I would have gotten younger friends. It just went on and on for her. She was not 107, but Claire lost her husband, and she lost her only daughter to cancer, and she had a huge falling out with her only grandson. So she didn't have anybody. Well, we also serve as medical power of attorney. If someone has capacity, but they have no one to name, and if they will put together a plan and tell us what their wishes are, we will, as a company, serve as medical power of attorney. So we became Claire's medical power of attorney when she was running around and living her life and doing everything on her own. And as the years went by, it was a blessing that we got to know her and got to know what her priorities were, what was the most important to her. Because her husband was a retired dean from one of the schools at UT, and she had what she thought was more than adequate resources, but they were dwindling. And even though she had a huge falling out with her grandson, she gave him a hefty distribution every year because that was her only blood relative. We were getting down far enough where we knew if she continued distribution, she would wind up in a facility because that's a lot less expensive than 24-hour care in the home. But we also knew She desperately wanted to stay in her home. So we had an interesting meeting of her trustee, her attorney, her son-in-law from years ago, they'd stayed in touch, and her grandson. And we sat and we had a meeting to say, what would Claire want if she could decide this? Because she was well past the ability to decide. What would she want? Would she want to continue distributing funds to her grandson, or would she want to stay in her home? Everyone voted the same, including the grandson. Discontinue the distributions for her to stay in her home. We could only do that by knowing her well enough and having the grandson, even at a distance, know her well enough to make a decision that's the decision she would make if she could have told us her decision then. So we're going to talk about this person now. I promise this will come to an end at some point, and I will stop talking about legal, I promise. But it's the most important piece of planning. If you don't have someone named, then this system will take over, and someone else is going to take you down their path. Medical power attorney, critically important. The HIPAA release, you've got to name every single person you would allow the hospital or the nursing facility or Westminster or Robin to talk to. And that could be your children, your grandchildren, your next door neighbor that's so close to you. HIPAA release doesn't give anyone any authority to do anything. It just lets them be a part of the discussion. Your spouse is not automatically someone who the hospital will talk to. And I know that sounds strange, but it's based on what was their most recent lawsuit. Did they accidentally give information to a spouse that wound up not to be the spouse? Or a spouse that was in process of divorce? You have to have your HIPAA release and the people named. Financial, you gotta have somebody pick up and pay the bills. That's your durable power of attorney. Your directive to physician directs what you want if you're in an irreversible or incurable or terminal condition. What would you want or not want? And then designation of guardian has to do with who you would want to serve if you are taken to guardianship court. Who would you want to serve? And more important, who would you absolutely not want to ever be your guardian? Very important document. So you have to name the right people that will execute your wishes. And the question comes up when you should execute legal documents. Does anyone have an idea when you should execute these advance directives?
Yesterday.
When? What age? Huh? As early as possible.
Somebody said it yesterday.
Yesterday. Yes, yes, but you've all done it and you're all perfect. Guess what age they should truly be executed?
18.
18. Who said that? There he is again. There's Tony.
I've been through it.
He's
My
all
son-
over
My
it.
son had pneumonia freshman year in college.
Yes.
If we hadn't had, if he wasn't able to sign, we didn't have the papers in place. But they wouldn't talk to my wife about his situation. We're in New Jersey. He's in Ohio in a hospital. And we had to get papers signed, so they didn't talk to my wife, and she could manage his care.
Yep, he was in the hospital in college. This is my bonus to everyone, and I tell it at every talk for the last, how many years, Hank, since Cameron? 6 years? Something like that. Our 19-year-old grandson having a wild party at the UT on spring break, took a fall from the third story onto concrete. Catastrophic injuries, head injury, many bodily injuries, orthopedic injuries. He was 19. He did not have advance directives. He didn't have a power of attorney. He didn't have a HIPAA release. And I'll tell you, when his mother, my daughter, walked through the doors to the ER, she arrived with two things: tears and fears. She did not walk through the door of the ER with legal documents. She had nothing. He was at Brackenridge when it was still Brackenridge. They would not tell her anything. They knew she was the mother because they found her number on him. They must have had a really bad lawsuit telling the wrong parent what was going on. As they're wheeling him to the surgical suites, he roused enough to give her permission to know what surgeries he was going in for. And that is the only way she knew for the first round of surgeries. They would not allow him, with his head injury, to execute documents. They would not tell her anything unless he woke up roused and said, "Yeah, you can tell my mama that you're giving me morphine." Denise and I did 24/7, round the clock for the first week in ICU because we couldn't find out anything. I can tell you, all of our grandkids, 18 years old, they get those documents. Simplest thing, print it out from the internet, but that's a gift you can give to all your family members, because I can promise you this much, they do not all have legal documents. So that's a gift.
What is the difference between a power of attorney and guardianship? Which is more legal?
Great question. Judy's asked what the difference is between a power of attorney and a guardianship. A power of attorney is when someone can sit down and they have the cognitive ability to name who they want acting on their behalf. That's done in advance. That's why they're called advance directives, because they're done in advance of incapacity. You can choose that person. Guardianship is when you can no longer choose and you have passed that up and something happens and there's no one to act for you. Guardianship trumps power of attorney. When a guardianship is given to a family member, an organization, part of the order is that any power of attorney documents that are in dispute are no longer valid or legal. But people don't usually know that. I'll tell you, we go in with a patient of ours under guardianship. We take it to the hospital, we take the legal documents, we say, here are the guardianship papers, and they say, well, where's the power of attorney? Guardianship trumps power of attorney. Any other questions about legal documents? Yes.
Only two more suggestions. One is, when is the power of attorney in force? My mother originally put it so that if she was incapacitated, it would be in force. And we had a situation where are you going to get a weekend in July a doctor to say she's incapacitated so that you can start paying medical bills or something? So we went to the attorney, and as a new attorney, not the guy who drew up the papers originally, convinced my mother that if you can do it now, make the power of attorney active immediately. He said, well, you're still conscious, because if you don't trust that person enough to do it when you're unconscious, you shouldn't be giving it to the person in the first place. So that's a lot of people don't know that, but it should be active automatically. And the other thing is that power of attorney is not recognized by Social Security Administration. There's a separate piece of paper you have to file with them.
Right. Social Security doesn't like power of attorney documents. They want all the decisions to be made by the representative payee. If you don't receive your own Social Security, but someone else receives it for you, that person in the eyes of Social Security has more power than the power of attorney, which is inaccurate, but that is the way they work. Most of us are receiving our own Social Security, so we are our own rep payee. But in the event of an adult disabled child, where the parent is receiving and administering Social Security funds, they would have more power than a power of attorney. But Tony brought up a really good question as to when power of attorney documents are in effect. There are two kinds. One can be power of attorney that takes effect immediately. As soon as you sign it, that person can make your decisions for you. Or there are springing powers that sit there, they're in place, they're valid, but they don't spring into effect until you're incapacitated. And many people, when they go in the hospital, are temporarily incapacitated. You know, they're delusional for a period of time under the drugs, under the anesthesia, and the hospital will turn to the person listed because ethically they have to. The person's impaired. And so that's pretty fluid in the hospital, even if their powers of attorney that may be questionable in the community, but in the hospital, they will defer to power of attorney documents. And then once the individual is out from under anesthesia and drugs and everything, they may go back to be their own power of attorney, or if there is confusion and some level of incapacity ongoing, then you can get a simple doctor's letter for two things, for the medical and or for the financial, that they can no longer manage their finances and you can take those over. Does that answer it? Yes.
Yeah, Debbie, will you, because there's a general power of attorney for financial and a medical power of attorney, and those are two different documents.
They are. Your durable power of attorney is your one for money, and the other one is the medical power of attorney, and they're two different things. Same in guardianship. There's a guardian of the person, and there's a guardian of the estate. So these are two different things, and very often you need different people in those roles. That's why they're separated. Other medical, any legal questions that would float into the medical field that I know?
Well, I have one more question. Will you comment on, so there can be a written advance directive, but it's my understanding there needs to be a family member, probably a medical power of attorney person, to advocate for those advance directives, as opposed to the physician just standing there and reading them.
You're so smart. She was talking about advance directives. When you hand them an advance directive that says that you either want comfort care or want everything done, what she's bringing up is the physician wants to hear the answer from the medical power of attorney. He doesn't want to read and interpret legal documents. He wants someone to make that decision, and the doctor does not want it to be him. So she's exactly right. That's why your power of attorney needs to know all your wishes, because legal documents can be broad and sweeping, but the decisions that need to be made in an urgent or hospital situation, in an acute care, they're little decisions. Can they have a blood transfusion if it's needed in surgery? Will you sign the surgical permit? They're not the big decisions very often as much as little decisions. So a well-educated power of attorney will have the answer to everything, and that is who the doctor will turn to, whether they are physically there or whether they're on the phone. If they're on the phone long distance, any authorizations require two nurses to get on the phone with the power of attorney, read through everything, and get the verbal okay from two people. So thank you for bringing that up. Yes.
Can the same person have
Yes, the same person can serve as both, but they are two separate documents. Very often in the medical power of attorney these days, they also have the HIPAA release embedded in that. But the legal, the whole durable financial power of attorney and the medical are two distinct different documents. So, yes.
My last observation is where the documents are stored. For example, if you have them in a safe deposit box at the bank, and you need them on the weekend, you can't get them. So what I did is I made sure the attorney made multiple originals of our documents, so each of my children have an envelope with our documents in it, and they don't have to come to our house to find the documents, because they've got them in their hand already, so they can go right from home to the hospital with them. And you have to take it every time to the hospital. My parents were in and out of hospitals the last 3 years of their life a number of times. Every time we went in, we had to bring the documents with us again, because the fact that we filed them early, it didn't count anymore.
Yeah. Tony, he's talking about where you keep the documents. Most people keep the original in a safe or in a locked place in their home or with their attorney, which is what you need after you die. But as long as someone knows where the originals are, and that's on the form that says where are the originals, then you can operate off of copies. All of our children, it's sad to say, have them on their phones because someone insisted they have them on their phones. Because when something happens, it's Saturday night and they're skiing in Vail, and that's when it happens. It doesn't take much to put your documents on your children's phones or your whoever is serving as your power of attorney. But that's the best place to have them, because you never know when you have to show up with them. Yes?
Many people here, I think, have signed DNRs, and I've been told that that's only valid for Westminster. If you're in an accident and you're hauled to a hospital somewhere, that DNR is no longer valid. Is that correct?
Bob's asking about the DNR, and I'm so glad you asked about that. We are going to just dive into that next time. But you are right. An out-of-hospital do not resuscitate is an EMS form, and the reason it says out-of-hospital DNR is because it is only effective out of the hospital. Anytime you go through the doors of the hospital, you are a full code until the doctor writes otherwise. I know that's shocking, but it varies. Let's say you go to the hospital and you have a broken hip and you go into surgery. I promise you, you will be on life support for surgery. So every hospitalization has to be evaluated as a unique case, and the doctor has to write what kind of code you are, and we will go into great depth with that on our final session, which is medical planning, and I'll bring DNRs for everyone as party favors. But there'll be favors. There'll be another fine gift for you, I promise. All right, I'm going to start to wrap this up and tell you about your handouts. This substituted judgment, you're all going to do an educational session for your children. Do not be my parent, be my voice. Got it? Also, there's included a medical planning worksheet. This is not an easy thing to fill out. This is only if you are voiceless. And I will tell you, the silver lining of COVID is we started talking about these things. If you wind up in the hospital on a ventilator, you cannot talk. You cannot think through critical decision making. You want someone who already has your thoughts on this. If you are so ill, especially at our age, so ill that you're on a breathing machine, you're on life support, you may have a temporary pacemaker floated in. If the decision is that there is very little chance that you will ever recover to your former life or ever live independently us what you want. Don't say, I want everything done or put me on hospice care. Think through some of the things, even like breathing. There's external breathing support. There's a tube that can be put down your windpipe to breathe for you. That can't stay in forever, maybe a week. And if you still need it, then you have to have a trach. There are different levels of feeding, of breathing, of life support, of dialysis. Tell your power of attorney what you would want and what you would not want if the prognosis is poor and there isn't an expectation of recovery. This is not a legal document, but just like, tell me what your name is in the church. No,
Peggy?
Peggy. Okay. That's why I wrote my book, while I could still remember it. Just like what Peggy talked about, the doctors are not going to read your legal documents. They're going to turn to the power of attorney and say, this kind of stroke, this individual is never going to return to independence. Power of attorney, what do you want? Well, when we go over these with our kids, I can promise you they won't remember it, but they know where the form is. They know we discussed it, they know it's written down, and they can pull it out and say, let me go to my cheat sheet, and let me tell you what Mama would want and what she wouldn't want. Now, the minute you wake up, you're your own person, and you can speak for yourself. This is only if you cannot speak for yourself. So go through it. If anyone is really in a quandary over this, by all means, give me a call, run by the apartment, knock on the door. These are important things for the people that do not want to decide for you. The guilt is huge, and it stays. Whereas if you tell them, these are my wishes, you just implement my wishes, it's a lot lighter decision. Another form is concessions, and these are just forms kind of randomly pulled from the blueprint, but these are concessions that you would make. When you can't stay in your apartment anymore safely, is that a time you want to move to a higher level of care? Is that a time you want to put on caregivers? We will all make concessions in our life, but this gives you the opportunity to write down the concessions that you would make. And then I'm also providing you with the lovely out-of-hospital do not resuscitate, which gives me a tremendous amount of comfort that I have this executed for myself. But these are the things, if you could just take some time, fill them out in pencil if we need to talk about it more next time, because we will. And then come back and we'll gather together and discuss all of the in-depth medical decisions, documentation, how you can give gifts to your responsible parties. So are there any questions about the homework? Y'all did really good with your legal. I'm so impressed. I'll see about medical. Sometimes it's a little touchier. I'm so sorry about the slides. What we'll have to do is understand that the MAC doesn't always like everyone's technology, and we'll be set up for either the MAC or for the Westminster. But the information is recorded and will go on the portal. And for the final time, first time we didn't have it recorded. This time we're not having slides. Next time, let's hope we have it all. So thank you for your time.
Thank you.